Ready, start. Taking exception to the impugned judgment, learned counsel on behalf of the appellants submitted that the High Court did not examine the grounds taken by the appellants and has assailed the concurrent findings of the courts below on multiple grounds. It is submitted that the prosecution's case is founded solely on circumstantial evidence and has failed to establish an unbroken chain of circumstances pointing only towards the guilt of the appellants. In his submission, several vital links necessary to establish their guilt are missing. First and foremost, it is contentiously submitted that the appellants, namely Najim and Aftab, were not named in the FIR. PW1, who lodged the report, suspected six other villagers with whom he had long-standing enmity but did not mention the names of the present appellants. Counsel contended that this omission in the earliest version of events raises serious doubt about subsequent attempts to implicate the present appellants. Learned counsel for the appellants assailed the credibility of PW2 Tawheed Ali, the scribe of the FIR, who later claimed to have overheard a conspiracy meeting on the night of 4/6 2007. Counsel submitted that his testimony cannot be relied upon for several reasons. First, although PW2 scribed the FIR at the dictation of PW1, he did not mention any conspiracy in that document, nor did he inform PW1 about such an incident when they met. Instead, PW2 surfaced with this allegation for the first time before the court during trial. Secondly, when questioned, PW2 explained that he had treated the conversation as loose talk, close, and therefore refrained from disclosing it earlier. Counsel submitted that such an explanation is implausible. PW2 himself admitted that he did not treat the matter seriously because of the pre existing enmity between the families. Thirdly, conspiracies are not ordinarily conducted loudly in social gatherings so as to be overheard by passers-by. The claim that the accused would openly plot murder during a feast within earshot of others seems improbable. Fourthly, the defense highlighted that DW1 Safiq Ahmad, in whose house the alleged meeting occurred, categorically denied that any feast took place on 4/6 2007, stating instead that his son's marriage was solemnized on 3/6 2007. The next limb of submission relates to the last seen close theory. PW3 Om Prakash claimed to have seen the deceased with the appellants, namely Najim and Aftab, on 5/6 2007. Learned counsel submitted that PW3 admitted in cross examination that he did not know the appellants earlier. Despite this, no test identification parade within bracket hereinafter referred as TIP close bracket close was conducted. Counsel submitted that when a witness is a stranger to the accused, a TIP becomes essential to test the capacity of the witness to identify the accused. Identification for the first time in court without the safeguard of a prior TIP carries little probative value and cannot be treated as reliable evidence of identity. Counsel further pointed out that PW3's wife Mithles and his son Pintu were allegedly present with him at the time of the sighting. Yet the prosecution chose not to examine them.